Okay, now it's hitting. Okay. Hi, this Miss Melinda. How are you all doing tonight? Oh, it's been 4 or 5 days since I filmed. Yeah. So I bet you guys missed me. I thought I'd do a really beautiful Hollywood diva costume. Since my yellow sweater got made 2 times, I wanted something really sexy. So how y'all doing? Welcome to Miss Melinda's Spontaneous Smart Diva Show. Yeah, so I could not finish the last 2 pages of my the last. This is the 4th category. Okay, so for those of you who don't know, we're on the judicial system, but we're on the very 4th, which is the last category of the judicial system, and it's called court procedures. And I've already taught 1 or 2 classes, so I had to stop. I just got 2 pages left. I just couldn't do it anymore. I got 26 pages. And I got the last 2 pages, all we got left. So you really got 90% of the whole class. Now, you're going to have to study this, and you're going to study all the judicial system classes. But we'll talk after class. Let's get going. So, the judicial system. Court procedures is the name of the 4th category, the 4th topic. And its legal procedures vary from state to state. I can't hold this. Hold on. I got to get comfortable without losing you guys. My baby finger started to hurt. Okay, I'm going to have to hold it like this. Like this. Okay. I have to hold it on the table. I'm going to have to. Okay, because I can't hold it anymore. All right, there you go. That looks good. But we need, if you go this way, you get more of a shadow, I think, from the lights. Let's see if we go back. No, I think it looks better like this. No. I have to turn more towards the table because you can't see my sexy red satin bustier. Okay, how's this? Okay. Okay, so here we go. This is the judicial system. This is pretty much almost the whole 4th category, with just 2 pages left. I'll finish tomorrow. So the judicial system, court procedures, 4th topic. Legal procedures vary from state to state and from court to court. This lack of uniformity has led legislatures and bar associations to try to reduce the number of disparities among various jurisdictions. By standardizing court procedures, legal terminology, and legal documents, standardizing legal procedures is of great value to the courts and the legal profession in the efficient administration of justice and the handling of cases in court. Okay. Paragraph. In an effort to simplify common law pleading, Congress in 1938 adopted, no, I got to look this way. Okay. Adopted a set of rules known as the Federal Rules of Civil Procedure. These rules, which are periodically revised, set out, I got to put this, I wanted to put this, I need to be able to get some of my waist in here. Do I have to bring it forward? Oh, bring it forward? But I can't bring the, I can't. You have to just go like this. Maybe a little back. Lean back. There we go. That looks good like that. Okay, perfect. Let's do this. Okay, let's start over. In effort to simplify common law, pleading. Congress in 1938 adopted a set of rules known as the Federal Rules of Civil Procedure. These rules, which are periodically revised, set out each step in a civil proceeding, including the method of preparing required documents in all federal courts. Since then, I have to get this, my belt. You have to bring it back. Like that. Yeah. Okay. Right about like that. Okay. So, these rules, which are periodically revised, set out each step in a civil proceeding. Okay. Including the method of preparing required documents in all federal courts. Since then, the majority of the states have adopted similar rules. Consequently, the rules of procedure in the state courts are to a certain extent now uniform. Okay, court procedures continue. Types of court action. Okay? Types of court action. The courts have responsibility in 3 general areas: criminal, civil, and equity law. In most jurisdictions, the same courts try cases in all 3 areas. In a few jurisdictions, special courts known as chancery, courts hear equity cases, and some states are separate courts for civil and criminal cases. Under the federal rules of civil procedure, there is no longer a distinction between law and equity in the preparation of pleading in federal civil law cases. Court procedures continued. Criminal actions. Okay. Criminal actions. Okay. Criminal actions. There we go. Okay. An individual or group breaking a law designed to protect society from harm is considered to have committed a crime, because the public has suffered as a result of the crime. The people of the state or of the United States bring an action, They are represented in court by a public official who may be known as a district attorney, a public prosecutor, or a United States attorney. The jurisdiction of each court determines the types of crimes that are to be prosecuted there. Okay, court procedures continued. Okay. Courts of limited jurisdiction generally hear lesser crimes or misdemeanors, while courts have general jurisdiction, try the more serious crimes or felonies. Court procedures continued. Civil action. Civil action. A civil case may arise when the actions of an individual or a group cause harm to another, who then goes to court seeking compensation for that harm. The injured party, called the plaintiff or complainant, asks the court to grant damages in the form of a payment of money. In some civil actions. And continued, in some jurisdictions, if either party in the case requests at a jury may hear the trial. If neither party requests a jury, the judge renders judgment after hearing both sides. After hearing both sides. In most civil actions, the party who brings the action must prove his or her case by a preponderance of evidence. That to me, also, as a court reporter and graduate of associate degree in paralegal studies, to me it says, in most civil actions, the party who brings the action must prove his or her case by a preponderance of evidence. I say, prove beyond a reasonable doubt, quote unquote. That's the way I say it, because that's another terminology in the courtroom. So that person that's bringing the action must prove beyond a reasonable doubt. See, the defending attorney doesn't have to prove beyond a reasonable doubt. I'm telling you this out of my own brain, out of my own head. The defending attorney only has to prove reasonable doubt. That's all the defense attorney has to prove, is reasonable doubt. The prosecuting attorney, the state, has to prove beyond a reasonable doubt to win. Okay. So, or the action will fail. It says if they don't prove preponderance of evidence, or my way, beyond a reasonable doubt, the action will fail. Okay. Court procedures continued. Equity actions. Okay. In most jurisdictions, equity actions are encompassed when civil actions, although a few states provide separate courts of equity. In equity cases, the party who brings suit is called the petitioner or complainant. The petitioner asks the court to order the opposing party, usually known as the respondent, to perform. Okay. The respondent to perform or cease from performing a special act. Equity will be sought when relief is not available to the petitioner through money damages. There is no right to jury trial at equity. The judge alone makes the decision of the judge in a case. In equity is technically a decree, okay? And I did look up decree for us. That will be taught. I did look up a lot of law rhetoric for you guys, but I'll have to teach you that one tomorrow. But decree's in there. Anyway, it says judge in a case in equity is technically a decree rather than a judgment. In practice, however, the words are commonly interchanged, and I will tell you the definition tomorrow of the decree. So, steps in criminal procedure. Okay, in criminal procedure, arrest. An individual may file an informal complaint with a law enforcement officer. Okay. May also make an arrest without a warrant if there is probable cause to do so. In some cases, a grand jury must be convened to determine whether there is cause to indirect an alleged criminal perpetrator. An accused taken into custody must be informed of his or her rights of representation and against self-incrimination. Court procedures continue. Okay? Bail is a deposit of money that helps to guarantee that an accused person will appear for trial at the time and date specified. After the accused has been taken into custody, the court may set bail and temporarily release the accused person. If he or she does not appear, bail is forfeited. Bail is forfeited, and the accused is considered a fugitive. If that accused can reasonably be expected to appear when ordered, the court may release the accused on his or her own recognizance. That is without bail, depending on local rules and the seriousness of the crime. Okay, fourth category that we're still working on, court procedures, okay? So the justice system, court procedures is the fourth category we're still working on. Preliminary hearing. A preliminary hearing is held to determine whether they're probable for holding the accused for trial. A preliminary may also be held to fix bail. In the case of certain lists, serious crimes, the preliminary hearing may follow the arraignment. We're still on court procedures. Well, it's the judicial system. Court procedures is our last one. Okay, the next step in a criminal procedure is an arraignment. Arraigning an accused person has three purposes. 1, to establish the identity of the accused. 2, to inform the accused of the charges. 3, to allow the court to hear the plea of the accused. Guilt, not guilty, no contest. Okay, trial is the next word. Still under the judicial systems and court procedures. Trial. The United States Constitution guarantees a right to jury trial in a criminal trial. This right, however, may be waived by the defendant. If the trial is to be heard before a jury, it's selected and sworn in. A trial jury typically consists of 12 categories. Okay? Wait. Typically consists, no, I looked away. I'm sorry. Let me start that over. So, okay, sworn in. A trial jury typically consists of 12 citizens who listen to the facts and present their decision. The verdict. In criminal actions, a unanimous vote of the jurors are usually necessary in a jury trial. The judge rules on points of law and the jury decides questions of fact. After the jury has been sworn in, the trial usually follows this sequence. 1, opening statement by the prosecutor. 2, opening statement by the defendant's lawyer. Parentheses, this may be delayed, however, until the beginning of step 4. Okay. We're still court procedures. Step 3, presentation of evidence by the prosecutor. Okay. 4. No, okay, you're on 4. 4, presentation of evidence by the defendant's lawyer. 3, it said trial continued. It said presentation of evidence by the prosecutor. That's step 3, okay? So let me clarify that. Step 3 is presentation of evidence by the prosecutor. Step 4 is presentation of evidence by the defendant's lawyer, okay? And then 5, closing argument by the prosecutor. 6, closing argument by the defendant's lawyer. 6, closing arguments by the defendant's lawyer. 7, the judge's charge or instructions to the jury. Okay? Okay. So, court procedures continued and trial. The word trial is continued. The judge charges the jury. Wait a minute. The judge, charges. The judge charges the jury instructing from regarding the law that relates to the case and provides guidance in reaching a verdict. The judge prepares the instructions, but prior to the trial, each attorney prepares and submits to the judge a set of requested jury instructions. In this way, each attorney can make sure that the judge does not overlook any point that the attorney considers important. Okay? So you got verdict, court procedures, verdict. Verdict. The jury retires to a private room and considers the case, and then a vote of the jury is taken to arrive at a decision. The defendant may be acquitted, found guilty, or a mistrial may be declared by the judge if the jury cannot reach a decision. If the defendant is found guilty, the judge has the authority to impose sentence, although in some jurisdictions, the jury will determine the sentence. The sentence is based on specific findings of fact as the presence of aggravating or mitigating circumstances and conclusions of law. The verdict is signed by the judge and recorded so that it may be included in the transcript of the case, which is me, the court reporter. I have the transcripts. I have to take dictation every word that is said by every person from the time people walk into that courtroom. I have to be stenotyping in my steno machine every word that is said by every person in that room. And I have to keep my transcripts under lock and key. You want a bunch of extra copies, hidden in different places. Because, you might get somebody, in this trial that says, hey, I'm going to that court reporter and I'm making her give me those transcripts. I need those transcripts. So I have to have them locked up, and you want it more than one copy in case something happens, that way. Okay, so as the presence of aggravating or mitigating circumstances and conclusions of law, the verdict is signed by the judge and recorded so that I may be included in the transcript of the case. If the accused is found guilty, the case may be appealed. After acquitted, a criminal defendant cannot be tried again. Same crime, and I told you, it didn't say it. I'm telling you out of my own head. A criminal defendant cannot be tried again for the same crime. It's called double jeopardy, quote unquote. They didn't tell you that. I had to tell you that part. Yeah, you can't be tried twice for the same crime. It's called double jeopardy. It's against the law. So you can't, once you're found not guilty, you're a free bird like O.J. Simpson. Okay, if a mistrial is called, there must be a new trial with the new jury. Steps in civil procedure. Okay? Civil procedure consists of 4 fairly well-defined, quote-unquote, well-defined phases. So phase 1, pleadings. Don't say it there. I'm saying it wrong. Hold on. Okay, civil procedure consists of 4 fairly well-defined, quote-unquote, phases. 1, pleading. 2, discovery. 3, trial and judgment. And 4, conclusion of litigation. Phase 1, pleadings. The general term pleadings refers to the series of written claims and defenses that establish what is in controversy or at issue, on what grounds the action is being used. Okay, complaint. Okay. Oh, and who is involved? And who is involved? Okay. Complaint. As the first step in a civil lawsuit, the plaintiff's attorney files a complaint, which may also be known as a petition or a declaration against the defendant. Where courts have equity exist, the first pleading in an equity action is called a bill of complaint or a bill in equity. Is that equity? I have to use fat magic markers because it's the only way I can see. Equity. It says, okay, let me say this again. The first pleading the first pleading in the equity in an equity action is called a bill of complaint or a bill in equity. The complaint states the specific injury suffered by the plaintiff, the acts of the defendant alleged to have caused that injury, and the remedy as damages be sought. Be sought. Okay. Summons. That was a word I was going to teach you tomorrow, but we got it here, so we won't have to worry about that one tomorrow. So just so everybody knows for sure, summons. The defendant must be given positive notice that a complaint has been filed. Okay, and that the complaint has been filed, and that a response to the complaint must be made. This notice is called a summons, and in most states, it must be served with a copy of the complaint. Once the action has been initiated by filing and serving the complaint and the summons, it cannot be terminated unless specified legal steps are taken. Also, once notice is received, the defendant must make some response to the summons and complaint when a specified time, okay, in order to avoid a default judgment, quote unquote. You don't want to make it a default judgment because now you're in trouble. So you must cooperate with this. Objections. Rules of court procedure require that a complaint be clear, definite, and complete, and that it be prepared in accordance with the law and the rules of the court. When the defense believes that the complaint is not in accordance with court rules or the law, the attorney may object to it by means of various written requests, such as a motion to dismiss on various grounds, a motion to strike, or motion for more definite statement. These documents and others attempt to invalidate the complaint. Okay, as these documents are points of law, most courts require supporting document to be prepared and attached. This document may be a brief legal memorandum or a memorandum of points and authorities. Answer. The next step in a civil action is the preparation of an answer in which the defendant responds to the factual allegations in the complaint. The answer must state an affirmative defenses that the defendant intends to use against the plaintiff's claims, or the defendant will not usually be allowed to assert assert them during the trial. Court rules in many jurisdictions permit the answer to contain a counterclaim against the plaintiff. The counterclaim does not reply to an allegation, but states a cause of action that the defendant has against the plaintiff. The defendant may also make a counterclaim or cross-complaint against another defendant. The cross-claim may be filed and served as a document separate from the answer, or it may be combined with the answer into one document. Okay? May be combined into one document. Additional parties other than the original plaintiff and defendant may be joined and made subject to the counterclaims, cross-claim claims, and third-party claims during the exchange of pleadings. Phase 2, discovery. When the initial pleading stage of litigation is concluded, the attorneys will attempt to locate all witnesses and uncover all evidence while learning as much as possible about the issues. The process is known as discovery. Numerous discovery devices are available, and the attorney must decide which devices to use. And when some devices are discussed below, we didn't have time to show you all the devices that you could get. You could Google that, or I can look tomorrow for you. But anyway, next word is interrogatories. And I learned this word, interrogatories, in court reporting school. I wouldn't have known the definition of that word in a million years. But in court reporting, they called questions interrogatories, okay? Interrogatories info may be obtained by means of a written set of questions in a court document, okay? Usually entitled interrogatories that require written answers. Testimony may also be taken by asking witnesses oral questions. This discovery activity is known as taking a deposition, which I would do as a court reporter. So if I was also working in a specific law firm, I would be taking depositions with my steno machine. Yeah, in the lawyer's depositions. I would be taking the depositions, and I would have to have those transcripts under lock and key, and extra copies hidden and locked in different places. Okay, so that requires written answers. Testimony may also be taken asking witness oral questions. This discovery activity is known as taking deposition, okay, or using oral interrogatories, questions. The manner in which the questioning can be conducted is precisely determined by the rules of civil procedure, and that's what our fourth category for the judicial system. So you have to study all the other judicial systems. You know, most of them are all together. I quit teaching other things because I wanted them all together, the judicial system. But there might be one or two floating out a little bit. So please study all the judicial system talk videos, and then you will understand. Everything will come together. Okay. So by the rules of civil procedure, subpoena, spelled sub, like a subway, pena, P-O-E-N-A, subpoena. When witnesses are required to give testimony in court, they must receive official notice that they are to appear. This notice is called subpoena. Some states require that witnesses who are to give depositions be subpoenaed. If an attorney knows that a witness may refer to certain documents or other evidence in this testimony, either in court or in a deposition, or if the attorney wants certain items admitted as evidence, okay? So a document called a subpoena, called a subpoena. This must be, I don't have I broke my prescription glasses, but I think it said ducis, so subpoena, ducis tecum, which is Latin, and maybe they're saying that subpoena in Latin is ducis tecum. I don't know, I have to, tomorrow, I'll have to look that up. Okay. Under penalty, you shall bring with you is required. This document tells a person to appear at a specified time and place. They're telling you you must bring this document with you. Yes, to submit when you get into court. So, to appear at a specified time and place. With those particular exhibits, documents, photos, or other items, parentheses, related to the suit. And that's it. Yeah, I got just 2 pages left. I just couldn't do any more. So, I talk really fast, so I want you guys to really watch all my talk videos. I want you to first just focus on all the judicial system, okay? Just find all the judicial system, which pretty much right now, they're all together. All the first, 5, 6, 7, and then you just look at the rows, and see if there's, because I have one where I'm wearing a black hat. I had it labeled linguistics phonetics when I'm wearing the black hat. And I realized, I got in there and listened. I said, this ain't nothing to do with linguistics or phonetics. This is my law class. The classifications of law. It's the beginning of the judicial system. So if you would kindly find my black hat and watch that first. I think it's the very first, or one of the very first in my black hat. I relabeled it. It's the judicial system, and it's the I just said it. Now I forgot. I just said it. So just watch over. I got scattered. So watch the black hat. It's the first. Oh, classifications of law is the first category of the judicial system. So find the black hat, please, and watch the black hat. But you're probably going to have to watch it. I mean, there's all different kinds of people watching me. I can have kids watching me, really. I could have grammar school or, high school or 20s, 30s, up until their 90s. Anybody can be watching me. So if you could start with the black hat and, if it doesn't sink in the first time, please keep watching that one first. Keep watching it. Watch it 5 times. If you have to take off, want to continue it on another day, you can do that. But get that, and then I think there's one other lost one out there, judicial system. If you can find that one, that would be like the next one I would have done when I was first starting teaching this law class. So, and then the rest should all be together at the very top of my my class, my law class. The judicial system should all be at the top and in a row, basically. I don't think I've put anything different in between anymore, because I decided I want you to learn this. So then you go to the very top, and if you want to stay in order, you'll go to the lowest and the last judicial system from the top row, and go to the left. So like you would look just at each video from the up at the top, if you could, instead of taking the very first video, because I'm just doing this now. So this is like the end of this class. I've only got 2 more pages, which is going to be done tomorrow. So I hate for you to jump here. Well, I would like you to watch this first since I did just do it. Yeah. But I want you to jump, then just keep following judicial system, keep following each talk video until you get to the last one. After you did the 2 floating ones with the black hat, that one and another one, then go to the last at the top and watch each talk video backwards until you get to this one. And then tomorrow you'll have the completed class. Okay, well, this was a hard one for me. 26 pages. How are you guys all doing? Anyway. So I wanted to give a real nice diva costume and have a good time tonight. I took off for 4 or 5 days. I just needed some rest. Well, I'd been shopping every day, and that also worn me out. Then I had to write for my classes and then film, and I have to say them. So I needed 4 or 5 days. This is, I think, my 5th day, and I worked. I did work in there. I did start the notes for this class about maybe 3 or 4 days ago. I actually made a whole 10 pages. And then the next days, I just needed to rest the whole day. I wound up too late because I forgot one night to take my night meds. And I mean, it was like going on 9 at night. So it took a long time for me to get to sleep, So how y'all doing? What you doing? This is Hump Day Wednesday. So did you have a nice day today? Yeah? Okay, well, it would be nice if you would please hit my like and subscribe. I would love for you to subscribe. More and more people have been subscribing to me because I'm getting more and more videos. And the more videos I make, and I'm making them much more educated than when I first started out. And you have to do 45 minutes to an hour, or you guys just aren't going to learn much and you're going to get bored and just leave, So, but if you, are in the middle of a long video and you just don't feel like anymore, you just put it on hold or you let it go and start over next time you feel like watching it. Or you can just, you touch it, you tap it, and it freezes it. And you could come back anytime later that day or night or the next day or 2 days. If you just freeze it, the file goes to the top of you guys probably all use cell phones. I just bought an expensive one and I still have to, get it going. Anyway, you just watch at your own convenience, but watch the judicial all like in the same row. It doesn't matter if you take off a few days. It doesn't matter how many videos you watch. But just stay with judicial for now so you can really get it. And I'm just going to have, tomorrow I will have the last 2 pages. So I want you, please, just to watch the judicial until you really get it. All of them. You watch like 5 times each. Then you can start, I would watch all my talk videos. I have a girlfriend who's been doing this for 7 years. But she's got over 300 videos. So it gets to the point where I say, hey, I think I'm going to jump on this one that's 2 years ago. And you'll see people hadn't made comments in over a year. So I'm basically talking in private to her. So we talk a little more private than we would in Twitter, So, please try to watch all of my talk videos. And please subscribe, so you'll make me happy. And you'll get to see my beautiful bright white teeth. See? If you subscribe, you'll see a lot more of my bright white teeth. So please subscribe. And we have lots of classes, and you're welcome. You don't have to just stay religiously to the judicial system. Jump around if you to get more of an idea. Maybe it is, you can jump through into other videos far away off of the judicial system. I really shouldn't push people. You should venture out, actually, to see more what I'm about. Yeah, you could. But the first few made, which are going to be at the very bottom, I look like a robot, and I'm talking funny, and I'm stuttering, and it looks like I can't concentrate or talk. And what it is I just bought this expensive tablet, and it kept moving my head. It kept moving where my head was being taken out of the video, the tablet. So I had to keep moving my arms to the left. And I would get my face in the video, and then it kept moving to the left further. So I had to keep turning my left arm further to the left, and it kept going further and further and further to the left. And it was killing my arm. And so that's why you see me stuttering and looking funny, and my head is stiff and straight and all that. Anything you see goofy. I'm in a fist fight with my new tablet. I still have to go for a class, actually. So I'm still not got this down to a science, but at least my face and everything's sticking in the video so you can all see me. Okay, I'm going to let you go since I worked so hard. And I really want you guys to watch this one. No, do watch this one first, and then go look for the black hat. Yeah, but watch them all 5 times each at your own convenience. And jump. You can jump the first time you come to you do this one first. If you want to go jumping around down some, go jumping around down some. But don't go all the way down, maybe. Well, some of it's real good, but some of them I'm fighting with the tablet. But just jump around if you want. See more of what I'm about. Okay, I'm going to let you go. You all have a nice night. I'm going to go open my window. I'm going to get under my electric blanket. I love to have my electric blanket on and the window open and a hot cup of cocoa. Okay? So you all have a lovely evening. And Melinda's been real happy to be here for you. And you could come watch me anytime. If you're down and out, come watch one of mine. I'm a happy person, and I don't talk depressing things, So I love you all, and I hope you'll subscribe, and we'll see you more often. Okay, good night.